Ma'am,
What?
this is not going to help.
It don't matter. My light's on. Anyway.
Well, looks like you did that, not me. I'll see you in 3 weeks. Which, come on, hold on, get her, don't let her go. Come back.
What?
I heard bullshit.
Everybody heard it.
You're bullshit.
Come back. You don't talk like that to anybody in this case because he didn't do this either. You did.
He got me the fee.
He did get you he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your
I gotta go to work. So I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. Still Bogan, this is sentencing. Good morning. This is Mr. Hoffpower sentencing. I didn't see you over there, Mr. Hoffpower. Good morning. Good morning. Are you Crystal Bogan? And Ms. Bogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yeah.
And any additions or corrections or speak up? I'm sorry.
I just want to make sure.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's... I mean, she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything? I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, ma'am.
school with this type of criminal history? Where do you live now? Okay. Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct? Well, it says $500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
But if it was a withdrawal, then that would be her responsibility joint and separately. So
Right. It says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, $94 from inside the bank, $500 from an ATM, and $100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the, yeah. So, I mean, if there was another person and you didn't give that information, then that's, okay. Apparently the cops didn't either, so, and hold on. So the probation's in Sutton County. Have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay. And so it's the state's position to go forward with the agreement?
I understand the court's concern. The state has the same. Like I said, our initial deal was to get someone like back on our victim. However, we understand.
All right. So here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. It has to be straight probation. And I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing. So
I don't.
you do.
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 hearings and one back here.
Okay. You have lots of them that were at the same time for different offenses. Yeah, you did probations for them. Forgery of a financial instrument. March, don't talk over me. March 3rd, 2008, Harris County, 180 days in jail. So that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation. So that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit. And that's the 10-year probation that you're on in 5 different cases.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all.
One.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this.
Smaller.
I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. Let's see. All right. I'm going to set your bond at $25,000. Go back with the bailiff. Let's see how today goes. I need the certification. Please. If I'm going to, we'll see. I mean, my main thing is a convict, and we're done with the first for her. So, see what y'all want to. All right, ma'am, you're Crystal Bogan. And Ms. Bogan, you were here yesterday for sentencing in cause number 25 DCCR 0026. Just so the record's clear, I rejected that agreement based on your criminal history. The fact that it was a deferred probation, I feel like with your criminal history, it is at this point, if you're going to accept responsibility, time for a conviction. You were going to be able to leave yesterday. There was an incident in the courtroom. Based on all of that, I raised your bond. Mr. Lewis asked that we bring you out today. Mr. Lewis, what is...
Well, Judge, yesterday afternoon, I went and spoke with Ms. Bogan about everything going on with the case. One, she did apologize to me, and she said, of course, when she had the opportunity, she wanted to apologize to you, the court, for her actions yesterday. I did explain to her as far as where we were as the case, the rejection was there on the deferred. You did kind of put at that point, he would have to be a straight probation with the restitution if she was to be on any type of probation. She told me she was more than willing to accept that. She understands how it may affect her with her job, but she wanted to still, if that opportunity was there, she wanted to definitely take it.
Mr. Hoffpower?
Judge, in light of all that the court's already mentioned and cited. We're going to leave it to the court, but we would not be inclined. We're on probation after the way she acted and due to her criminal history. So we would,
Well,
if the court wants to allow her to do straight, that's fine. I understand.
yeah. Well, that's what your argument was yesterday.
Yeah, well.
To continue for me to go forward. So, I mean,
True.
the most important thing to me, obviously, I don't know that you deserve a probation at all with your criminal history. But as I said yesterday and today, it is time for you to have some responsibility and some consequences for continuing to commit felony offenses. You know, it's great that you can finish a deferred probation, but at some point you got to quit getting felony offenses and quit violating the law. And so I don't think that's fair at all. So what I can do, I have the paperwork still from yesterday. And if you guys would want to agree to a convicted probation, I can make that modification on this punishment recommendation. And then I can kind of reinstate everything up to the plea and all of that. So we don't have to go through all of that. So I'll reinstate everything we've done prior to today, make that modification on the paperwork and go forward with sentencing. Is that everyone's agreement?
That's fine.
That's fine with us.
The modification will be a 2/5. It will be a 5-year probation. It will be a convicted 2/5. I am going to, I'm not inclined to order a fine because I want that restitution paid. So I'm going to mark through that. So with everyone's permission, I'll make that change. And that's what everyone's agreement is. Is that correct? And it is, I want to make sure you understand that this is now your agreement. And so if I follow an agreement to give you 2 years in the state jail, but probate it for 5 years, order that restitution, you can't change your mind later. This is your agreement. Is that correct? Okay. All right. Then what I'm going to do, let's see, restitution. And the restitution will be that $10,000. And that's everyone's agreement as well, correct?
Yes, correct.
All right. Then at this time, Ms. Vogan, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your new agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $10,000 fine, restitution and to follow all of the rules and conditions of probation. If you do this is still a good opportunity because you will be able to serve that 2-year sentence while you're out on probation instead of in the state jail prison. The other side of that, though, is if you violate any condition of probation at all, you will be brought back into court and you will be facing that 2-year sentence that I just gave you. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, ma'am. Do you need my PSI? I printed it out. Okay, you've got everything. I'm sorry, I just printed my PSI. Y'all can throw that away.
Orders, but I have them.
You have them? Okay.
Judge, if it's okay, the court is going to be able to apologize.
Yes, ma'am. I appreciate that. Make sure that while you're on probation, that you don't let those emotions also get in the way of you being cordial and doing what you're supposed to on this probation, as well as the other one that you're on, because that just in itself could get you right back in here. Even if you disagree with whatever they're ordering, if you disagree, you disagree. But you have to do everything they said. You have to be cordial. Thank you for your apology. You can go back with the bailiff.
Thank you.
Is that the way the case should be evaluated for punishment at this point when somebody's failed on probation? Or should she receive some sort of additional sanction on top of what that punishment would be because she's failed at probation? Are people punished in addition on the sentencings because they failed at probation? Does that entail an additional punishment? And I would suggest to the court that it shouldn't in her case. She hasn't received any new offenses. She's paid the restitution. So looking back at what an appropriate sentence would be on the revocation, one should look at the case as it was, and the circumstances as it was when she received the deferred, and the court should ask itself, well, what would be the appropriate punishment if she hadn't taken deferred at that point? And I think in looking at that, the court hopefully would agree that at 1244, I would say 1244B, where she doesn't have the felony convictions, but certainly a 1244A is appropriate. That actually convicts her of the state jail offenses, but would give her the county jail time of 180 days, 180 days state jail, or 180 days county with the state jail conviction, although I would hope that the court would consider 1244B, where she would just receive the misdemeanor convictions. That would be in line with what the facts of the case were at the time that she received the deferred. Now, obviously, she hasn't done much on probation other than pay the restitution, but should she receive some sort of additional sanction or punishment for failing at probation, separate and apart from the underlying offense? And I would argue to the court that in this circumstance, that would be inappropriate, that a 1244 would be the proper way to proceed.
Mr. Coleman?
Thank you, Your Honor. I'll be brief. This is one of those rare instances where Mr. Kimler and I agree she has failed abysmally at probation. Those were his words, and I join him in that sentiment. Judge, she's only paid the restitution now that an MTRP is hanging over her head. She's essentially done nothing since she was placed on probation. She goes on to probation in June of 2024, and she's not reporting the very next month or two after that. She's done nothing in the way of satisfying the conditions of her probation. Conditions, Judge, that are not recommendations by the court or suggestions by the court. It's your order. You ordered her to do these things, and she just disregarded the court's order. Even more than that, it is a waste of time, a waste of resources that could have been devoted to another defendant or defendant's judge. And based on that, I'm asking the court to revoke the defendant's probation and sentence her to no less than 12 months in the state jail.
And I would just respond, Your Honor, briefly, is would 12 months have been appropriate when she originally pled?
Well, I don't know that I agree that, and I think it's a case by case situation, but where we give someone an opportunity, where I give someone an opportunity and resources that someone else could have taken advantage of, I don't know that I agree that it should go back to what it originally was. You had an opportunity, and there should probably be punishment for what you did and possibly something for what you didn't do when you were given an opportunity to not have 2 felony convictions on your record. I can tell you now, 1244 of either type is out of the question. So here's where I am. Ms. Capel, Capel, you've stated, you've agreed that you have a substance abuse issue. They tried to get you some help through JCDI. Your option today, I'm going to give you an option. 2 things. If you want to not have a conviction on your record, a felony conviction, you want to try to be successful and do better and get the tools to do better, then I'm willing to do that. But it's not going to be getting out today. It's going to be inpatient treatment through the ISF program, which is the 90-day program. Then you get out, and then you're go through JCDI as aftercare, so that you can hopefully live the rest of your life without being here and looking at go to prison. If you don't want to do that, then I'll sentence you somewhere in state jail prison time. But it's not going to be 1244. You're not going to get to sit in county jail and do your time for not doing anything you were supposed to while you're on probation.
Would the court be inclined to indicate what the length of state jail would be to evaluate the court?
It would be somewhere in the range of what Mr. Coleman is asking for. I don't think that is an inappropriate ask.
What do you want to do? Yeah, she's checking her back. I think she has around 2 months right now.
The thing is, and I'm not going to try to talk you into doing something, because if you don't want to take advantage of what I'm offering you, that's fine. But here's the thing. If you want to just do your time, I get it. It's probably easier to do your time and get out. But you're going to be a convicted felon 2 times over. 2 felony convictions on your record. You're not going to be able to get certain jobs. You're not going to be able to live in certain places and apartments. You're not going to be able to vote. It's going to change your life. If you think your life is negative now because you're on probation, it becomes 10 times worse with the actual convictions. If you want to take your chance and do that, then you can. But if you get out and you continue to use, you continue to do things like steal and forge checks because you're using to try to get money to use, you're going to still be in the same place and you're going to be back in here. Then you're going to be looking at felonies that are enhanced because you already have felony convictions. So that's my spiel. I'm trying to give you an option here today that is probably not what you want in the short term, but is a whole lot better in the long term. So, do you want me to hold it for a minute? Y'all can go visit?
Yes, Your Honor.
All right, go talk about it. Let me know what you want to do. Can beg somebody to. Mr. Gertz on Chad Holland. I see it. Got it. 24 DCCR 1616.
No, I hear you. Please, no messenger shooting today.
I don't ever blame you for advocating for your client.
Maybe I should charge some extra at a trial. Maybe that was.
Run your shop the way you want to run your shop, Mr. Gertz.
That wasn't very nice. I guess it was nice.
Good morning, sir. You're Chad Michael Holland. And Mr. Holland, in cause number 24, DCCR 1616, you're charged with the third-degree felony offense of fraudulently securing documents by exception, I'm saying the wrong, deception, but it says executed documents. Anyway. And that offense is from December 30th of 2023. Your indictment alleges that you were previously convicted of burglary of a habitation March 15th of 2004. And after that was final, you were convicted of fraudulent use of identifying information October 7th of 2020, and also possession of a controlled substance, a second-degree felony, October 7th of 2020. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is a minimum 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here that shows that the district... What's going on over there? Everybody needs to, if y'all are going to be here, you need to sit up straight in your seats. We can get you a comfy seat up here if you want to come be closer to the action. But if you're going to be here, you don't sleep in court. That's disrespectful, okay? So sit up. Get your hand off your head. Everybody sit up. Eyes open. Pay attention, please. So I have a plea bargain rejection that you've signed with Mr. Gertz that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be plea into counts 1 and 2 only for a 15-year term in the institutional division of the Texas Department of Corrections. Do you understand what your possible consequences are if you go to trial and what your options are?
Yes, sir.
And do you want to reject that offer and have your case set for trial? Yes, sir.
I'm sorry to interrupt you. I'd like to point out that that 15-year offer was a one-time today on the offer. I communicated that to Mr. Gertz that I would waive one of the enhancement paragraphs or a couple of the enhancement paragraphs to get us to that 15 to 99 punishment range. But,
Okay.
I have every intention of proceeding on the habitual offender if
Sure.
if we go to trial.
And y'all talked about that. And so, Mr. Holland, I want to make sure you understand that after today, I will not accept this plea agreement. If you change your mind later and want to enter a plea of guilty, it would be to something different than this or to the indictment with the minimum 25, unless there's some new information or evidence that comes to light that either Mr. Gertz or Mr. Coleman don't know about today. Do you understand? And you want to reject that offer and go to trial. Is that correct? All right, we'll get it set on the trial docket. Mr. Gertz will begin preparation. Mr. Kimler on John Mayen, sentencing, 23 DCCR 0461. I'm sorry? Yes, hold on Mayon, please. Somebody's here. Who's coming in?
We're about to tell them we don't need them because I think we have an agreement.
Okay.
If you follow, it's the recommendation of probation.
On who, what?
Corbin Thomas.
Corbin Thomas, sentencing.
The report suggested ISF, even though we essentially got kicked out of safety. It seems kind of limited, though.
Okay.
It's a MTRP for messing up safety.
And he's fine with that?
They want to
Mr.
retire.
Kimler?
Yes.
Well, on Thomas, y'all have an agreement?
Yes, sir.
Let's get Corwin Thomas, please, ma'am.
We could, I can just tell them that we reached an agreement.
Where are they? Sandy.
Sandy, outside Corpus Christi. That should be Lieutenant Perez here.
You're gonna hand him anyway?
No, I was gonna let them know. Hi, Lieutenant, can you hear me?
Can you unmute yourself, please?
We're not, it's just.
Okay, yes, I can hear you.
Hey, Lieutenant, this is Luke Nichols with the Jefferson County DA's office. We've reached an agreement, so we're not going to need your testimony this morning, but I want to thank you for making yourself available.
All right, sir, thank you.
Have a great day.
Thank
You
you.
too.
All right, sir, you are Corwin Thomas Jr. And Mr. Thomas, you were previously in court and entered pleas of not true to counts 1, 2, and 3 in a motion to revoke your probation. So I'm guessing we need to go back through that motion for change of pleas. Is that correct?
Yes, sir. Yes, sir.
Give me a second. Let me pull this up. And Mr. Thomas, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And will he waive the formal reading again of that motion?
So wait,
So now, how do y'all want me to do it? If I've already revised one and I'm going to do it again, take the original and do it again, or take the revised? The revised. So make another copy of the revised. Mm-hmm. All right, so there's a motion to revoke your unadjudicated probation, and cause number 24 DCCR 0542 shows you were placed on probation for aggravated robbery July 29th of 2024, and that was a 10-year deferred probation, correct? And so it alleges that in count 1, you failed to never become intoxicated or under the influence of an intoxicating substance, and that you were on February 10th of 2025. And is that true or not true? True or not true?
true or not?
Listen to my question. True or not true? Thank you. So then, count 2 alleges that you're behind in your court-assessed fees. Is that true or not true?
True.
And then count 3 alleges that you did not successfully complete the safety program. Is that true or not true? Did you enter your pleas of true freely and voluntarily? And because those 3 counts are actually true. All right, and I've received an updated report before, if y'all both had an opportunity to review that report.
Yes, sir.
Yes, sir, we have.
And it's my understanding that everyone is of the opinion that even though you didn't successfully complete SafeP, that I give you an opportunity and send you to ISF to see if you can get through that and then hopefully be successful. Is that your understanding? Is that everybody's?
Yes, Your Honor. It's based on the probation officer's recommendation and my understanding and agreement that with his age and the severe consequences facing him if he is revoked, that a chance at ISF to get on better decision making and a chance to actually complete.
And is it, Cognitive or substance
It
abuse?
appears, the recommendation appears to be substance abuse. I don't know. That's,
Is that what you suggest?
Substance abuse and followed by JCDI?
correct.
Okay. You know, I could send you to prison today for the rest of your life.
No,
That's how serious this is. If you don't make it through ISF and you come back here without ever getting out because you did whatever was going on in SafeP, if that all continues, there won't be another chance. And you're going to go to prison before you ever even really get out to get on probation. So I want you to take advantage of this, because I'm going to look back at this and I'm going to probably think, why did I do this? And you don't want me to think that later, because it usually ends up really bad. I want you to be successful and I want you to take advantage of all of these opportunities, but you're going to have to go in there with a different mindset. You're going to have to get past however it was, whatever you were doing out on the streets, however you were living. If you want to live a normal life, have a family, have a job, just live normally without all of this in prison, then it's time for you to come to that decision and take advantage of this. Do you understand? Okay. So I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation and order that you enter and successfully complete the substance abuse track of the ISF program, and that you will then, when you're out, do the outpatient treatment through JCDI. All that's meant to help you make better decisions, get off drugs, do the right thing. If you do that, you still don't have the felony conviction on your record. And so you'll still be able to live your life without saying I'm a convicted felon. But if you violate, like I said, you'll be right back in here. You can be convicted and you could go to prison for anywhere between 5 years and up to the rest of your life in prison. You understand? All right, take advantage of this. Good luck to you.
Thank you, Mark.
Yes, sir.
Let me chisel this from now for a moment.
Okay. Mr. LeBlanc on Preston Fontanet.
It could be a future of you getting to tell me.
Do what?
With the Cora Thomas in the future, it could be you get to tell me I told you.
I know, right? Every now and then it happens that way. Every now and then.
But
All right, so this one, he pled to counts 1, I guess,
paragraph 1 contains a
count 1 previously, so we're just gonna go through that again. All right. All right, will your client waive the formal reading of the indictment?
I'm sorry.
Will he waive the formal reading of the indictment? Mr. Fontanet, in cause number 23, DCCR 20, sorry, something just popped up.
2079.
I just had stuff start coming on my computer. 2079, the state's elect to proceed on count 1 only. It alleges you committed the 3rd-degree felony offense of unlawful possession of a firearm by a felon September 29th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. LeBlanc?
Yes.
Do you fully understand them? And do you understand, if I follow this agreement, that you'll be waiving or giving up any right to appeal? Also, and so the agreement is the same as before. It's a 10-year sentence in prison that would be probated. You'd be on probation for 10 years. Fine, was there a fine?
$1,000 fine.
A $1,000 fine, and you would be required to follow all of the conditions of probation. Is that your understanding? Speak up, please.
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
We have no objections, Your Honor.
It's admitted. Is there any evidence that Mr. Fontanet is not competent?
None that I'm aware of, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. We've already gone over the pre-sentence report. Is there any reason not to go forward with sentencing?
Not in light of his renewed plea, Your Honor.
Then at this time, I'm going to find sufficient evidence to find you guilty and find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, and your probation revoked, and you would be facing that 10-year sentence that you've already agreed to. Do you understand?
Yes, Your Honor.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. LeBlanc. All right? Good luck to you, sir.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Jeremiah Johnson, Mr. Parker. Oh my gosh, I'm gonna need, y'all wanna, did y'all print any of those? Jeremiah Johnson by chance? It's got 4 cases. On Johnson's cases, are we going on the indictments as they are, or are there changes? Okay, I'll get through them. Y'all don't have to print them. I'll figure it out. Yeah, I got it. I'll do it. Nope. If I don't have to change them, I can, I'll get through it.
Judge, I did not write CC on there, but they're all, the deal is to run CC.
Okay. Good morning. Are you Jeremiah Johnson? And Mr. Parker, will your client waive the formal reading of the indictment in each case? Just a second. Mr. Johnson, in cause number 25 DCCR 0330, you're charged with a first-degree felony offense of aggravated robbery from February 27th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 0331, you're also charged with a first-degree felony offense of robbery from February 27th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And again, are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In cause number 25 DCCR 0408, you're charged with the state jail felony offense of theft of a firearm from February 27th of 2025. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And then finally, in cause number 25 DCCR 0409, you're also charged with the state jail felony offense of theft of a firearm from January 30th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? In all 4 of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, you'll be waiving or giving up any right to appeal?
What I have to do as a kid, so?
Yes.
Alright.
And so it looks like the agreements that you've reached with the district attorney's office in the two ag robbery cases is for a 10-year deferred probation with $500 fines, and then a 5-year, is it 5?
2 over 5, 2 years, probation for 5 on the state jail.
And then a 2-year term in state jail prison with a conviction, but probated for 5 years on the theft of a firearm case. Is that your understanding of your agreements? So on the 2 aggravated robberies, it would be 10-year deferred probations, which means no convictions on your record on those 2. But if you violate a probation, it gives me the whole range of punishment. On the 2 state jail felony offenses, it would actually be a conviction of the state jail felony with a 2-year term in state jail prison. But that is, the agreement is to probate that, and you'd be on probation for 5 years in those 2 cases. Is that your understanding?
And the cases all run CC.
All right. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And there is also a $500 fine in each of all 4 of the cases. Is that your understanding as well? State tenders number 1 in each
No
case.
objection.
It's admitted in each case. Is there any evidence that Mr. Johnson is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we will come back at a later date for sentencing. All right, you can go back with the bailiff. Jack Hooper, Mr. Parker. Good morning, sir. Are you Jack Hooper?
Yes, Your Honor.
And Mr. Parker, will your client waive the formal reading of the
You
motion?
will, Your Honor.
Mr. Hooper, in cause number 17-27896, I have a motion to revoke your community supervision. Shows that you were placed on probation June 11th of 2018 for the offense of driving while intoxicated, third or more. That was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
It's true, but I get.
Well, hold on. We're gonna get to the reasons or explanations
Okay.
later. Right now, I
Yes.
just need to, if it's true or not true. Okay? Count 2 alleges that you provided a urine sample February 18th of 2020 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample September 24th of 2020 that also tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you provided a urine sample January 26th of 2021 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
And then count 5 alleges that you failed to provide verification of attending 2 meetings per week of AANA. Is that true or not true?
That's true.
And then count 6 alleges that you're behind in your court-assessed fees as of February 4th of 2021 in the amount of $2,109. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes.
And because those are actually true.
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Not really, no, ma'am.
Okay, what do you not understand?
Well, I don't know. This first thing, I've always been the same thing. So I've never really been in trouble, you know. I'm kind of a country boy and I got a lot of medical issues.
Okay. So you understand that there's a reason that there's a motion to revoke your probation,
Yes, I do.
that you violated your probation, and these documents show me that you've made an agreement with the district attorney's office. If I revoke your probation for a cap of 4 years, which means if I follow this agreement, the worst I could give you is 4 years in prison. I could give you 4 years. I can give you 3, I can give you 2, I can continue on probation. It'll all depend on the information that I get when we come back for sentencing. Do you understand that?
Yes, ma'am.
Is there anything now that you don't understand about what's going on?
No.
I've explained all the options to him thoroughly, Judge, about he could go open to the judge, he could say it's not true and have a hearing and you make your finding.
Sure.
I feel confident he understands.
Okay. State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hooper's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing so the probation department can do an updated report. We'll come back and have a hearing on that date. Anything that you think is important for me to know, make sure you discuss that with Mr. Parker and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff.
On Warren Mills, Judge, it's one we reset to get the offer. I was just informed yesterday about 3 o'clock to get the video. And it was just ready yesterday, and Luke brought it to me this morning, so we can have a short reset so I can show him the video.
Who, Mills?
Warren Mills.
All right, we'll reset Mills.
Thank you.
Thank you, sir. Mr. Kimler, are you ready on Christy Capel?
Yes, Your Honor.
That paperwork back, please, ma'am. All right, again, ma'am, you're Christy Capel. And Ms. Capel has motion to revoke in each of those cases that we were talking about before, gave you an opportunity to visit about what you wanted to do or what you wanted me to do, and what do you want to do? Okay, good. That makes me happy. I think that's better for you in the long run. So I'm going to find that you entered your pleas of true to counts 1 through 5 in each of your cases freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probations, but I'm not going to do that. I'm going to continue you on each of these probations in order that you enter and successfully complete the ISF substance abuse track, and that you then, when you're out, go through the JCDI program as your aftercare. And then any counseling that's necessary for whatever you're going through is going to be offered, and you need to take advantage of it. Keep these off your record, live your life again like the rest of us, and hopefully this is your opportunity to do that. You still don't have the convictions, and so if you successfully complete it, the cases will be dismissed. The other side of that, though, is if you're back in here, I will see everything that we've gone through and done. And the arguments and the offers, I'm sure Mr. Coleman will remind me of what he was suggesting, and it probably will be worse on that time. Do you understand? I'm going to hand you the trial court certification. This wasn't an agreement. If y'all will sign that real quick, I'll get it. Even though I didn't revoke, let's get a copy of that. Honestly, we don't even need that. Never mind. If I didn't revoke her, I don't need to do that. All right. So good luck to you, ma'am. Take advantage of this opportunity. And then, Mr. Kimler, are you ready on John Mayen? Let's see. John Mayen?
I'm sorry.
I'm not opposed if you go around with the probation's recommendation.
Thank you. And all kinds of handing out the chances today. How are you, Mr. Hill? Good. All right, you are John Mayen?
Yes, ma'am.
And Mr. Mayen, you were previously in court, entered pleas of true to counts 1 through 5 in a motion to revoke your unadjudicated probation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Are there any additions or corrections?
No, Your Honor.
Not from the state.
How old are you now? 21.
Yes, ma'am.
So you understand that today you could be going to prison for the rest of your life for violating this probation.
Yes, ma'am.
Okay. You ready to do better?
Yes, ma'am.
Okay. You're lucky because probation also thinks that you are ready to do better. And so they've given a recommendation that I continue on probation and give you some treatment up front, some ISF, cognitive track, and then to give you some tools to be successful. Is that what you want me to do?
Yes, ma'am.
Anything else, Mr.
Not from the state.
Okay, it's already done. All right, so I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation in order that as a condition of that probation, you enter and successfully complete the cognitive track of the ISF program. You will be ordered when you're completed that for some time. You'll be on the high-medium caseload risk, which just means high-risk caseload, which just means you'll be reporting a little more often. They'll have a better watch, make sure you're following through with everything you're supposed to for some amount of time. If you do all of this, get the tools that you need when you're in ISF to make better decisions, do everything you're supposed to on probation, then this is your opportunity. So this is your second chance. There won't be a third. Okay, you got a great chance getting on probation in the first place for this offense. The fact that you're remaining on this probation is a big deal. And so if you come back and you haven't followed through and taken advantage of this, I can assure you things will not go this smoothly next time. Do you understand?
Yes, ma'am.
All right.
Is there anything you wanted to tell? I know he wrote extensively.
I read your letter. I mean, and that's part of why I think everybody's willing to give you an opportunity, because it sounds like at least in your mind you're ready to get things right and your priorities straight. It's just getting it from here to actually doing it, right? And so it's being around the right people or being around no people at all. Go to work, go to school, go home. You know, if you want to live your life out like a normal person and not in prison for who knows how long on a case like this, then you're going to have to make some sacrifices and do everything you're supposed to on probation and make sure that it doesn't matter what anybody else around you's doing, you're doing what's right for you. All right? All right, good luck to you, sir. I'll sign that order.
Defendant needs to sign those as well.
Oh, he does. Then he just, yeah. Mr. Kimler on Peyton Woodruff.
That's a motion to release.
Bond.
Essentially, when you get to.
Late yesterday, but thank you.
So why that's not a tag, refund.
That's okay. I'll, is it in both cases?
It's the 100,000 is in one case, the other bonds are small part.
I'll call it one,
Right.
and the state filed something in both.
Gotcha. All right, are you Peyton Woodruff? And Ms. Woodruff, in cause number 25 DCCR 0426 is charged with robbery, and in cause number 24 DCCR 1710 charged with burglary of a building. Mr. Kimler has filed a motion asking that I reduce the bond in the burglary of a building case. And it looks like the state has filed
start a couple of responses, Judge. We're not necessarily opposed to a reduction in the $100,000 bond. I can see where the court would be inclined to do that, but we just made some points in our reply for the court to consider.
Let me take a
What happened? She was on bond for the burglary of a building and then was arrested on the robbery, alleged to have committed the robbery while on bond for the burglary of the building.
That appears to be what I'm seeing, yeah.
And that's why it was raised.
What's the bond in the robbery?
And,
It's 15.
that's right, Judge, 15,000 in the robbery.
15?
Yes, Judge.
It's a simple robbery, not a robbery. It was basically a shoplifting case.
It's the garden variety.
It's garden variety robbery. It's
All
not-
right.
Still, it's a second degree robbery while you're on bond for another
Disparaging the severity of
felony.
or attempting to impede the severity of But basically,
Hold.
she wants to go into rehab, if the court ready to entertain the motion. And I said as a condition of lowering the bond, that she be court ordered to attend Franklin House North as a condition of lowering the bond. Do you want to do that? Is that right, Peggy? You wanna do that?
Hold on just a second. Let me look at something else here.
And she has unindicted possession cases as well,
And I guess those are just waiting on labs.
That's my understanding, Judge.
which could be, who knows how long.
I know. Same offense date as which one, the robbery or the burglary? Or are they different offense dates? Do y'all know?
Oh, different offense dates is my understanding. I put in my reply, that it looks like she picked up the POCS while she was out on bond for the robbery. Well, let me reverse that. The defendant was out on bond for the POCS when she picked up the robbery, is my understanding.
She's out of bond for the burglary.
Burglary of a building.
Burglary building.
She was
That's
probably let out on accusation on the,
There is an underlying substance abuse problem, as the court made from the facts.
give me just a second. I'm reviewing, just for the record, I'm reviewing the probable cause affidavit and cause number 25 DCCR 0426. All right, so, Mr. Coleman, you're not necessarily opposed to some type of reduction, but I think there's some very,
That's how the court would be inclined to reduce that $100,000 bond. I just would ask that it be sufficient in light of the circumstances, including the fact that she's got 5 pending criminal cases, 3 of which are felonies, and she picked those up, all 5 of those offenses within the span of 4 months, Judge. You know, there's an argument to be made for the protection of the safety of the community in light of her recidivism, but that's really a simple idea.
And if I could briefly explain my position. Your
Yes, sir.
Honor. I think there's a lack of criminal history here such that I think that would the state be prepared to extend a plea offer on the indicted cases, it would probably be probation. I don't want to speak out of turn, Mr. Coleman, but certainly the cases that she has that are presently indicted should be probation cases, but probably with the condition of safety or ISF. Since the state's not prepared to make an offer at this time because of the unindicted cases, she's just sitting in jail with the $100,000 bond and is not able to try to initiate a rehabilitation program in jail. And I don't know how long she's going to be sitting in jail waiting for these new cases to be indicted. So that's.
well,
Yeah,
we're not gonna,
because-
I don't know that we can wait on the possession cases, depending on the time frame that is
That's
going
right.
on with those issues right now is not something that I'm willing
I
to.
would like to move the indicted cases.
Well, let's do okay, all right, so in cause number 24, DCCR 1710, I'm gonna grant the motion to reduce the bond in that case to $25,000. I am going to, order that you enter and, successfully complete the Franklin House North program. Also, that you are required to wear a drug patch. Your bondsman or Mr. Kimler can let you know where to get that on. You have to get it on if you make your bond within 24 hours. You have to wear it properly. You have to get it changed every 2 weeks. If it tests positive, that bond in each of your cases is going to go up. If it's not testable, then I'm going to assume it's positive. So whatever you have to do to make sure it stays on your arm, that it's testable every 2 weeks, you have to get that done. And then we'll reset the case for an announcement. If for some reason that bond's not made, we'll see where we are at that
And
point.
as I said, I think I would be prepared to plead her.
But y'all talk about that. That's all right.
Thanks.
Thank you. Mr. Lewis on Derek Ardwan, 25 DCCR 0350.
And more before we settle that.
Okay. Justin Thomas needs an
He
evaluation.
does, sir.
We're going to reset Justin Thomas. And we'll get, if you'll send something over, or we can just do our order on Justin Thomas. Morning, Mr. Lewis. Good morning, sir. Are you Derek Ardwan? And Mr. Ardwan is charged in cause number 25 DCCR 0350 with sexual assault. And what is the announcement?
Judge, I can talk with Mr. Smith about the resolution on this matter. And I think we're close, but I think he would like to speak with the family first before, so we could just, maybe 2 weeks.
Okay.
Maybe get it resolved.
All right, Mr. Ardwan, we'll reset your case a few weeks. Make sure you talk to whoever you need to so that when you come back, we can get an announcement on what you want to do with your case. All right, you can go back with the bailiff. See, Norberto Armenta, Mr. Lewis, Ms. Molfino. Good morning, sir. You're Norberto Armenta?
Yes, ma'am.
And Mr. Armenta, in cause number 25 DCCR 0168, you're charged with driving while intoxicated, third or more. And in 25 DCCR 0169, charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, on Mr. Armento's case, there's several pieces of mitigating evidence that I'm getting released from his property and being sent to me. I've gotten an offer from Ms. Molfino, but I've talked with her about this, about reviewing that information with me, and it could possibly change the offer so we can get it resolved.
Okay.
And Judge, he's indicted as habitual. We've made an offer considerably under that based on some mitigation
Okay.
factors, but I would just like the defendant to know I'm happy to keep that open based on everything we're going to continue to discuss. I didn't want him to think it'd go back to the original.
Okay, thank you, Ms. Molfino. So we'll just do a normal reset. That should hopefully give you time to get whatever you need from Mr. Armenta and his property. Get that to Ms. Molfino. We'll see if we can get an announcement at the next court date. All right, you can go back with the bailiff. Marcus Elam, sentencing, Mr. Lewis.
Marcus Eagle.
Good morning, ma'am. Good morning. You're Marcus Elam? And Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation on probation for burglary of a habitation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections to the report?
No, nothing's been finished.
And it was unagreed. Mr. Lewis, you may proceed.
Judge, this is a situation where it's no doubt that Mr. Elam made several mistakes while he was on his probation, not following up on his obligations. After speaking with him, he's been in custody this length of time here. He is definitely, from what he's telling me, willing and wanting to comply with the court's orders, and feels as though he could successfully complete this probation if given that opportunity. He understands that his mistakes, has definitely been costly and put him in this decision. He understands that's totally on top of him, and of course he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Yes, ma'am. I'm sorry for my actions that I did when I was on probation. And if you really, I would like to start over and get right, live with my family, go back to work, help my mother out, give her bills, and everything else, Your Honor.
Okay.
And Judge, I'm sorry, I was gonna say, Judge, if I may, one of the biggest issues I explained and talked to Mr. Elam about was him not reporting like he was supposed to do over that span of time. And he expressed to me that at that time he was dealing with the death of his grandmother, as far as I think she was a big part of his support system. He does have, I've been in contact, several members of his family have contacted me about him, so he does have a support system that's there. I think she was a big part of it. And after she passed away, I think he kind of went astray at that point, my understanding, Judge.
What is the status of the 5 new offenses that are alleged?
I believe they should all be.
What happened? So what was the deadly conduct from August of 2023? What was the outcome of the, or I guess I'm trying to figure out what happened on all of them.
My understanding, Judge, is he has cases that are pending in misdemeanor court, but nothing here, Judge, that's been accepted as any additional.
I mean, he pled true to the deadly conduct, discharging a firearm, from August 16th of 2023. Anna, can you tell?
I'm sorry, Judge, I didn't look him up after he pled true.
I know, I just want to know if I want to know that. I want to know the evading, the failure to ID from February of this year. I want to know what the status of everything is.
I know those are still pending. He hasn't gone to court on those yet, right? Right. Next door.
Andy Cohen.
Mainly the August 16th, 2023 offense dates are the 2 deadly conducts. I want to know what the status of those are. And PCs, if you can find them.
There's the evading for March 3rd, 25. Our case, but one it's on, and then there was a previous trespassing case.
There's 2 deadly conducts that should be somewhere, somebody should know something about from 2023.
There was an obstruction in 2023 that was dismissed. I don't have anything on deadly conducts.
What's the offense date of that one, the 2023?
5/3/23.
Daily conducts from August of 23 were refused, Your Honor.
Do you have any, I guess if they were refused, you don't have any documentation or a PC
I
or?
might be able to see a reason, Your Honor, for the refusal. I'm gonna pull that up right now.
Thank you.
There's not. Just said unlikely to prove. There's only one.
I mean, you got true to it, so obviously there's that. All right, Ms. Malfina, what's the state's position?
Judge, I'm kind of torn on him. Obviously, the concern is the length of time he absconded. I mean, it wasn't just a month or two. They looked for him for almost 2 years, a year and a half at least. And in that interim time period, regardless of them having been filed or refused or whatnot by the intake division, he has pled true to at least the court standard of having committed all of those new offenses while on probation, although he has no felony convictions. It looks to me like he ordered him to ISF cognitive in 23. Mr. Lewis had made mention that he never went. I don't know if they didn't have a bed for him and eventually he timed out of that, or something happened and the new offenses came up and they wouldn't take him.
I think when he had the prior NTRP, I don't know if it was at the new case or prior NTRP, I'm not sure, but ISF was ordered, but at some point, I guess after he timed out or something because he was released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to due to pending legal issues at the time, and he was ordered to complete moral recognition therapy in lieu of, but he never.
So it was the new offenses that were holding him up.
Correct.
It looks like there was a non-prosecution affidavit on that assault and violence, which is why it was
He pled true to it.
correct.
So,
I just want to let you know that's
yes,
why it wasn't there.
perfect. Thank you. So this is this. So there was a motion to revoke back in 2023. And I'm guessing continued on probation in August or sometime, right? Or did we never do anything on that because then it was amended, first amended?
That's the one who's ordered us.
In March of 23, he pled true to that
March.
assault, family violence, the deadly conduct, obviously before it was refused, and you ordered him to ISF cognitive, plus the MRT program. And subsequently, there was another NTRP.
Right.
So you get an opportunity to be on probation for a burglary of a habitation. And I'm want to really make sure I've got this right. So you get deferred probation for burglary of a habitation, 2nd degree felony. You get out, you commit 3 new offenses, 2 deadly conducts, discharging a firearm, and an assault family violence on that same date. Regardless of what's come of those cases, you've admitted that something happened on those that day, right?
Mm-hmm.
So you come in front of me on a motion to revoke your probation. I say, okay, let's give you an opportunity to go to ISF. But because I guess something else must have been pending, maybe misdemeanors or something, you don't go to ISF. So you end up just getting out, getting another opportunity, and then you go and evade arrest or detention and fail to ID. We're back here again. And you want to start over and you're sorry. Think about how that sounds. And you just quit going for 2 years, a year and a half, year and 7 months. You just think you were going to get to be out and we were going to forget about you? You know, I mean, how old are you now?
23.
23. You started this when you were 19. Feel like you're not taking advantage and you're not growing up and making better decisions.
Spies has tried to work with him when he would show up to work with her, so, I mean, I don't object to revocation, Judge, and the opportunity that we've given him.
I mean, I don't know that it makes sense for me to do anything else. And it's just so frustrating, honestly, for me, for the young people to keep coming in here with offenses that have to do with shooting while you're on probation for a felony. You're shooting. Then you get out again and you violate again and you take off. So I can't give you a fourth shot. That you've had your shots. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You need to sign that and you'll get a copy of it. You do have some rights to appeal. You can talk to Mr. Lewis about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you. You can go back with the bailiff. Frederick Gatlin, 2 cases. Mr. Lewis. Gosh, so tough. It's not tough. It's just, I don't know. Good morning, sir. Are you Frederick Gatlin? Speak up, please.
Yes, ma'am.
And will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Let's see. Mr. Gatlin, in cause number 25, DCCR 0405, you're charged with the second-degree felony offense of failure to comply with sex offender registration requirements from February 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? Well, are you sure? What do you not understand if there's something you don't understand? Speak up, please. Okay, so I want to make sure you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal. Do you understand that? So if I follow this agreement, you can't change your mind later. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone that. You're a U.S. citizen, correct? All right. State tender's number 1 in that case.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Gatlin's not competent?
No, Judge.
All right, sir. In cause number 25, DCCR 0405, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements and sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 23, DCCR 0230,
In that case, the state would abandon, would go forward on counts or paragraphs 1 and 4 and abandon the remaining counts or paragraphs.
thank you, sir. All right, so in that case, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 3rd of 2023 for the offense of failure to comply with sex offender registration requirements, and that was a 10-year deferred probation. Is that correct? The state's elected to proceed on counts 1 and 4 in that motion. Count 1 alleges that you failed to report as directed to the probation department December 12th of 2024, and is that true or not true? And count 4 alleges that you failed to register with the sex offender tracking program as ordered. Is that true or not true? Did you enter your pleas of true to counts 1 and 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I also have here on the computer some documents in that case that have your signature on them that the state's marked as exhibit number 1. Did you also sign and go over these with Mr. Lewis? And do you understand them? And do you understand, if I follow the agreement in this case that you've made with the district attorney's office, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection, Judge.
It's admitted. All right, Mr. Gatlin, in 23 DCCR 0230, I'm going to find that you entered your pleas of true to counts 1 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. You have been handed the trial court certification in each of these cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Lewis. All right? Good luck to you, sir. You can go back with the bailiff. Roel Gonzalez, Mr. Lewis, Roel. Let me say his name. Oh, he's incompetent. I was gonna say we could ask him. I think it's been a lot. So we've just got him and Reed. And Joel, is he on his way?
Told you 15 minutes at 10:38.
We're getting closer, everybody. There's a lot this morning. Tommy. It's a, uh-huh. Critic and a comedian all at the same time.
Okay.
Good morning. Are you Roel Gonzalez? And this is cause number 25, DCCR 0226. I'm going to take judicial notice of the court's file. Mr. Gonzalez was evaluated for competency to stand trial. I have received the report from Dr. Hamza dated April 14th of 2025. The finding in that report is that Mr. Gonzalez is not competent to stand trial and that inpatient restoration would be supported. Is there any other evidence with regard to competency?
No, from the defense judge.
Not from the state judge.
All right, then at this time, based on that report, I am going to find Mr. Gonzalez not competent to stand trial. I'm going to order Mr. Gonzalez to the appropriate facility for competency restoration for a period of not to exceed 120 days from the date you get to that facility. Mr. Gonzalez, you're going to get some, go to a hospital, get some doctor's care so that you can come back and then take care of your case once you understand everything. You can go back with the bailiff. Deontay Reed, Mr. Lewis,
Yes, ma'am.
and Mr. Coleman.
Yes.
Good morning. Are you Deontay Reed?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You would be.
Mr. Reed, in cause number 24, DCCR 0838, you're charged with the state jail felony offense of theft of a firearm from January 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You'd be ordered to pay a fine of $1,000 and restitution in the amount of $1,500 and follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenors number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Reed is not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That way I can get more information about you, your case, and then we'll come back later for sentencing. Mr. Coleman, what is the state's position with regard to bond reduction based on that plea agreement?
Your Honor, I would point out that the defendant does have a lack of adult criminal history. However, my records indicate he does have a aggravated robbery as a juvenile, and the firearm or firearms that were stolen in this case were never recovered as well. Would ask that you,
I think I'm going to wait. I want to wait and see I want to know what went on juvenile. So we'll just leave the bond the way it is. We'll get a pre-sentence report done. That'll give me all that information and we'll come back for sentencing. All right, you can go back with the bailiff. Thank you, Mr. Lewis. Okay. He's probably going, I guess he's got his PSI. He's going to go over his PSI. Okay, one more. Mm-mm. I don't understand. Okay, let me visit with him right now.
it's
Did I-
chatty down there in the 279.
It will help.
His lawyers like to talk.
All right, sir, are you Tony Fears?
Yes, ma'am.
And this is cause number 24, DCCR 1028. Mr. Fears was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
Not from the state. None from the defense.
And I'm guessing even though there's significant history, Mr. Smith, based on the nature of the facts, or?
Based on the totality of the circumstances, I felt like this was appropriate. I did speak with the complaining witness. He was concerned when I spoke to him about the restitution, even though the PSI kind of says he downplays that.
Was that part of the, was there?
Restitution was paid up front already.
Oh, it was already paid?
Yes.
Okay, okay,
And I had forwarded that on to the complaining witness.
okay. All right, then, Mr. Fears, at this time, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Can there, we can't do it straight. It has to be deferred because there's deadly weapon.
Deadly weapon, I'm sorry, Judge.
Yeah. So, look, I caught it as we, I should have caught that yesterday when I was reviewing it. So, which actually, in my opinion, might be okay because that gives me the full range of punishment. So what I'm going to do then, the type of probation is left up to the court anyway. But you cannot have what we call a straight probation on an aggravated case. And this is an aggravated case. And so I'm going to kind of recall what I just did. And instead of making that finding of guilt, I'm going to defer all proceedings. You're placed on probation for 10 years. So it's still the 10-year probation, but it's a deferred probation. There's a $1,000 fine, and you're required to follow all of the rules and conditions of probation. So the difference about this is if you successfully complete this probation, then at the end, the case is dismissed, and you'll never have this felony conviction. The other side of that, and really kind of the side with your criminal history that I even like better, is that if you violate any condition of probation, you can be brought back into court and you could be found guilty and you could be sentenced anywhere in the range of punishment, which means between 2 years and up to 20 years. That 10-year cap or 10-year sentence is gone. It's now an open punishment range for me if you violate. With your criminal history, that's something that should be a deterrent for you, because I'm going to look back on this if you're back in here and wonder why in the world I agreed to this in the first place, because your criminal history does not support what's going on. I trust the attorneys. They know the case. I'm going to go along with it. But if you're back in here, it's not going to look good because I'm going to see all of this and wonder what in the world. Do you understand?
Yes, ma'am, I do.
All right. Part of your probation, and it's part of the law anyway, is obviously because you're a convicted felon on other cases, you are not allowed to possess any firearm. I'm also going to order that you not possess any type of weapon, knife, other than a kitchen type knife. You cannot carry a knife on your person or anything like that. Do you understand?
Yes, ma'am, I do.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will talk to you before you leave today. Good luck to you, sir. Thank you, sir. You too.
Thank you, Judge.
Thank you, Mr. Vasquez, Mr. Smith.
Thank you, Judge.
Thank you, Mr. Vasquez, Mr.
Thank you, Judge.
Thank you, Mr. Vasquez, Mr. Smith.
This courtroom hearing took a dramatic turn when a judge was faced with a defendant whose extensive criminal history made a proposed probation deal extremely difficult to accept. At the beginning of the hearing, the court reviewed a theft of property case involving a guilty plea. The original agreement called for 4 years of deferred probation, a $1,000 fine, and restitution. But once the judge reviewed the defendant's criminal history, the situation changed completely. The report showed a long list of previous offenses, including multiple felony convictions and misdemeanors that had not been dismissed. The judge also questioned whether the defendant could realistically pursue her plans for nursing school with this kind of criminal history hanging over her. Then, another major issue surfaced: restitution. The paperwork listed restitution at $9,400, but the court heard evidence suggesting the total amount taken was actually around $10,000, involving money withdrawn from inside the bank, an ATM, and a Cash App transaction. The judge made it clear that it did not necessarily matter who physically made each withdrawal if the defendant and another person had been working together. The judge then reviewed the defendant's criminal record in detail. One prior case involved forgery and resulted in jail time. Other cases involved forgery, theft, attempted drug possession, possessing criminal tools, and additional offenses in Ohio. The judge continued going through case after case, eventually reaching multiple cases in Sutton County involving smuggling of persons for pecuniary benefit. At one point, the defendant disagreed with the way the cases were being described, but the judge wasn't convinced. And then came the moment that changed everything. The judge rejected the plea agreement and reset the case for 3 weeks. But the situation quickly became even more serious. As the defendant reacted, the judge heard something she apparently said toward her attorney. The judge immediately ordered her to come back and warned her not to speak that way to anyone involved in the case. The judge made it clear that the defendant's attitude was making the situation worse. Then came the consequence. The judge announced that the defendant's bond was no longer sufficient because of her attitude and criminal history, and raised the bond to $25,000. The defendant then became emotional and said she had to go to work and was worried about losing her job. But the judge's response was firm. She reminded the defendant that the courtroom